Section 24 says the confession made under inducement, threat, promise is not relevant. Section 25 says the confession made to the police officer is not relevant. Section 26 says the confession made to any person when in police custody is not relevant. But what if there are some important facts admitted in the process? Can those facts can be taken into consideration? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were discussing chapter 2, which is all about relevancy of facts, covering from section 5 to 55. Here in this video, we are discussing one of the most important section, that is section 27, which discusses about how much information received from accused may be proved. This is very important because this has direct connection to fundamental rights. We are discussing this section with the help of illustration, with the help of chart, with the help of case laws, and finally we are discussing it along with fundamental rights. I'm not wasting any of your time. Let's get into the first slide. I hope you observed my introduction part. I started with section 24, 25 and 26. Why did I do so? Because section 27 is an exception to section 24, 25 and 26. Section 27, which is on how much of information received from accused may be proved. This particular section starts with provided that. That means this particular section is referring to previous sections on confession, that is section 24 and 25 and 26. Now this section is an exception to all those sections, and here certain amount of information received from the accused may be proved. But under what circumstances? It says when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. Now that's a lot of English. Let us try understand this particular section with the beautiful chart. The first term, as I have already told, is provided that. That means section 27 is an exception to section 24, 25 and 26, and that is what exactly held in the case law Muhammad Inayatullah versus State of Maharashtra. Now look at the chart. When an accused gives any information, so who is giving information under section 27? When any information is given by an accused. That is very important. Information here is given by an accused. Now, if such information given by the accused, if it helps to find a fact, okay, there is an accused who has given any information and such information helps to find a fact. And to whom and when is he giving such information? He is giving such information during the police custody of a police officer. That is very important. Here the information is given during police custody of a police officer. Now, such confession or statement, now we are not sure whether it is a full confession or a statement. Whatever it is relevant to the extent of if its connection is there with any of the fact which can be discovered, or to the extent of its relation to such fact which is discovered. If you ask me, section 27 is about two important words, recover and discover. Let's try understand this with the help of an illustration. Imagine Mr. X is an accused in a murder case. Police discover a fact that X has murdered ABC, and after the murder weapon, that is the gun, he has thrown in a particular well. Police go there and recover the gun. Now here, Mr. X's confession to the extent of recovering the gun is proved. That is a valid or relevant fact in this particular case. However, the confession that he has made to the police is not valid. Now, only to the extent of such information which is helpful to find out a fact or a facts in issue is relevant under section 27. I hope that is very clear. All we need to remember that the confession made under section 27 is also not valid, but the information which is helping to find out a fact is valid. Now you might be thinking that why so? Under section 24, 25 and 26 we have completely ignored these confessions, but suddenly under 27 we started thinking on considering certain information. Why so? Because the ultimate objective of law is to reach justice. That is why we are considering the information given in the process. That is what held in the case law of Bulakwi versus the Crown also. It was held that the confession made to the police officer in police custody shall not be proved. However, if there are any information given in the process, if that is playing a corroboratory evidence role, in that case the same shall be considered, because the ultimate objective of law is to reach justice and such information helps in doing so. The same importance was again held in the case law of Panduranga Kallu Patil versus State of Maharashtra, where it was again said that section 25 and 26, while they are absolutely banning the admission of confession, section 27 gives a certain opportunity for utilizing such confession for further discovery of facts, which helps the court to prove other facts related to the case. That is what held by Supreme Court. Little more details was discussed in the case law of Pulukuri Kottaya versus King Emperor case, where Supreme Court told that both physical as well as psychological aspects are important under section 27. Physical facts like dead body, a weapon or ornament, etc. will help to take the case further. Likewise, the psychological facts like concealment of weapon by the accused are showing his psychological intention, which are also very relevant. That was what held by Supreme Court in this particular case law. For example, in dacoity, theft, etc., if the stolen goods are found, that is almost corroboratory evidence for the entire process. That is why the physical as well as psychological aspects are important, which was held here. The last case law that I am discussing here is Muhammad Inayatullah versus State of Maharashtra, where it was held that statement which helps to the extent of discovery of fact is admissible. However, confession is not admissible. That is what held here. With that, I am going to section 27 versus the fundamental rights from my next slide. Several times there was a question came in front of the court that whether section 27 of Indian Evidence Act is breaching Indian Constitution. Now there are several such instances. I am giving 3 important case laws. However, due to time constraint, I am discussing only one case law and giving name of other 2 case laws along with articles. Now here I am discussing about Article 20 subclause 3 of Indian Constitution versus section 27 of Indian Evidence Act. What does Indian Constitution Article 20 says? It discusses about protection in respect of conviction for offences, and subclause 3 discusses about no person accused of any offence shall be compelled to be a witness against himself. The constitutional validity of 4 sections of different law came into discussion in the Supreme Court 11 judges bench in the case law the State of Bombay versus Katikalu Ogad. Now, which are the sections? Section 73 of Indian Evidence Act, which empowers the court to direct a person to provide handwriting or signature samples. Section 5 and 6 of Identification of Prisoners Act, which allowed a magistrate to obtain a photograph or measurement of a person. And section 27, that is from Indian Evidence Act, which allow in evidence statements made by the accused while in the custody of a police officer, which result in a discovery of other relevant evidence. All of these came for discussion. Here, after lengthy discussion, Supreme Court held that to consider someone under Article 20 subclause 3, he needs to satisfy four important requirements. 1. He must be an accused. 2. He must have been compelled. 3. Such compulsion must be to be a witness. And 4th, such witness against himself. So, when an accused is being compelled to be a witness against himself, Article 20, subclause 3 comes into picture. It was further held that mere taking any impressions like thumb impression, foot impressions or finger impressions, or showing body or body parts or specimen signature by the investigation officer for the purpose of comparison is not violation of fundamental right as under Article 20 subclause 3. However, if there are any compulsion made to give any kind of evidence against self, that is considered as violation of fundamental rights, but information given by the accused itself cannot be considered as violation of fundamental rights. That is what held here. If you are further interested to study the section 27 of Indian Evidence Act versus fundamental rights, you can study the case law, that is State of UP versus Dioman Upadhyaya, where Article 14 violation was discussed, and Selvi and others versus State of Karnataka, where Article 20 subclause 3 as well as Article 21, that is life and liberty, was discussed. Here in this case law, involuntary administration of certain scientific techniques like narcoanalysis, polygraph examination and the brain electrical activation profile, that is BEEP test, for the purpose of improving investigation efforts in criminal cases. All of such aspects are discussed in Selvi and others versus State of Karnataka. You can study more about this case law also if you are interested in section 27 of Indian Evidence Act versus the fundamental rights. That's my time on section 27. I hope you enjoyed the coverage. I will see you in my next class. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.